Paula Sullivan was involved in a head-on motor vehicle collision. She received permanent and severe damage to the frontal lobe of her brain. This acquired brain injury led to a series of changes in her behaviour, and one of the results of this was that she had 2 children to 2 different men between the accident and the trial, and exhibited impulsive and forgetful behaviour. One child went to the father's family, and the other was essentially cared for by Ms. Sullivan's mother. At trial, her lawyers argued she should receive specific damages to compensate her for the loss of her capacity to look after the children. Prior to the accident, she had capacity to look after children when she eventually had them. After the accident, she clearly did not. In a previous case, Bernickel and Cutelli, the courts awarded damages for this type of lost capacity, but it was part of the general damages awarded as a result of the injury. Ms. Sullivan argued that this loss of capacity should form a special head of damages because it had forced her to obtain external help in order to look after her children. This was similar to Griffith and Kirkemeyer damages, where a plaintiff is compensated for the cost of personal services such as nursing when they lose capacity to care for themselves. The result of receiving special damages rather than general damages would usually be that far more damages would be paid. The court agreed that this should be its own head of damages. Justice of Appeal Beasley said, "I cannot see any logical basis for the distinction drawn in Bernickel and Cutelli between the measure of damages in a traditional Griffiths and Kirkemeyer claim and the measure of damages for the loss sustained by the inability to care for a dependent child." The decision does not, in my opinion, reflect the true nature of a claim of this type, based as it is in a loss of pre-accident capacity which gives rise to a specific post-accident need. Ms. Sullivan therefore obtained specific damages to compensate for her inability to care for her children. Sullivan and Gordon damages were only in existence for a few years before the High Court overturned this form of damages in a case called CSR and Eddy. Nowadays, legislation in each state determines whether this sort of compensation can be paid.